do you think that the longer they take, I know it's no hard and fast rule, but do you see any correlation between the amount of time versus them really digesting it and writing an opinion, or is it just any man's guess?
It's this any man's guess. It's this man's guess. So I've had a similar experience where, you could file something and it's been out for a while and you're like, surely I'm getting a written opinion on it, whether they're going to reverse or affirm or
Yeah.
whatever. I don't know what it's going to be, but surely I'm getting a written opinion on this. And no, there's a PCA. Oh, yes, it is a mystery on the PCA. And to talk about the PCA, if you don't mind me
Yeah.
speaking about a little bit. So it stands for per curiam affirmed. It means that the appellate court, after it conducted its review, that they did not find that there was anything either. And it doesn't mean that the appeal is meritless. It just means that they didn't find anything that would advance the understanding of the points of law raised or points of law that need to be addressed that was worth issuing an opinion. And there are great Florida Bar Journal articles out there. I think there's one. It's like, oh no, not a per curiam affirm or something along. I'm paraphrasing, but there are articles out there that talk about PCA opinions and what they mean, why they exist. And frankly, they exist because the court's work isn't going to advance the points of law, that are already in existence in an area, than to take up the judiciary's time to write, these opinions when it's already been written before. Something it's like, this has already been written on, we disagree that we need to write on it any further. The trial court, didn't depart. There's no reversible error. The facts are supported by competent, substantial evidence. The court applied the law correctly, so on and so forth. There's just no reason for us to elaborate on this further. So they're allowed to, and they don't. And I know that it can be frustrating for the appellant, especially because you're like, I've got this great argument. I know I do, and everything. And the other thing that people, and again, it kind of gets into those standards of review. What the trial court did often goes to the appellate court, what is called clothed in the presumption of correctness.